Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers the 14th Amendment, medical care for arrestees, and reckless endangerment, and is brought to us by Tom Breen's channel. Be sure to check out the description below and give them the credit that they deserve. Before we dive into the interaction, I want to give a big thanks to the sponsor of this episode, Manscaped. Today we're talking about the Beard and Balls bundle, which is exactly what it sounds like. One package to tame your beard and your, well, you get the idea. If you're anything like me, then you've had more than a few hairs ripped out by cheap trimmers. Thanks to Manscaped's new Lawn Mower 5.0 Ultra, those days are over. It's smooth, precise, and has two interchangeable skin-safe blades. One for trimming, and one for a foil shave, so close it might as well be a wax. This thing is basically the F-16 of trimmers. It's waterproof, so you can use it in or out of the shower, just don't drop it down the drain unless you want to test that IPX7 rating for yourself. It has batteries that last longer than some relationships, a dual LED spotlight so you can see what you're shaving, and a travel lock so it doesn't set off any alarms at the TSA checkpoint. But they didn't stop there. The bundle also includes the Beard Hedger, which has a titanium-coated T-blade and a zoom wheel that gives you 20 length options, from the barely there stubble to full-on lumberjack. It's just as waterproof and durable, and it doesn't feel like a toy in your hand. Both trimmers come with accessories, travel bags, and chargers, so you're not left hunting for some off-brand cable or tossing them in a sock drawer. Right now, Manscaped is offering members of the ATA community 20% off and free shipping when you order the Beard and Balls bundle using code AUDIT at manscaped.com. That's 20% off and free shipping with code AUDIT at manscaped.com. Don't treat your body like a fixer-upper. Clean it up with tools built for the job. Thanks again to Manscaped for sponsoring this episode. On June 19, 2022, officers with the New Haven Police Department in Connecticut responded to a weapons complaint at a block party celebrating Juneteenth. At the party, officers identified 36-year-old Richard Randy Cox as a suspect and confronted him.
Yeah, I'm going to drive the other way. All right. Look at this. Oh my gosh. It has to be.
It has to be. 100%.
Yeah, it is. Yep. That's exactly it.
What's up, buddy? Hey, can I talk to you? Can I talk to you for a second?
Hold up real quick. What's up? Hold up real quick.
Just hold up, bro, okay?
All right, what's up? Is there anything on you?
Anything on you?
I'm on my phone. What? I'm on the phone with the girl. Cover my mouth.
All we're doing is detaining you right this second, okay? Done. Done. Sarge, 75!
Let's put on a glove.
Are you a permit holder? You heard? Don't move.
In the microphone.
Yep. You got anything else on you? You got gloves on? What's your name? Hey, what's your name? What is your name?
Yes, yo. Tell her call my sister, please.
He said, please call. He said, call his sister, please. She said she coming.
All right. Hey, all right. I walked off and my mother called me. You heard? I don't know. I didn't argue with nobody. And Liz was with me. Liz with my mother. They was with me.
Sir, I need to ask you if you have.
I'm sorry to hear that.
Sir.
Yo.
Hey, do you have a permit? All right, hop in. He's good.
Let's enjoy the rest of the party.
All right.
We'll do everything else at PD7.
All right. I'll try to get my license. Little big guy. White girl.
Carl, this is we'll turn around. We'll go out. Let them enjoy.
I'll meet you. Diaz with the 17. He's good. Yeah?
After he was positively identified, Mr. Cox was placed under arrest for possession of a firearm, breach of peace in the second degree, and carrying a pistol without a permit. The officers placed Mr. Cox in the back seat of a police cruiser and transported him to a police substation, where they waited for Officer Oscar Diaz, who arrived at approximately 8:30 p.m. with a transport wagon to take Mr. Cox to the New Haven Police Department Detention Center for processing.
Yeah.
We're just going to leave those cuffs
That's
on.
fine.
And then he's going to tell me to detention to hold on to him.
All right, I got to go down to one anyway.
I mean, you can go down to one anyways and grab him.
Yeah, because I'm going to log in.
But there's no point to us trying to change him now. He knows he's going down for
That's the guy, right?
Oh, yeah.
He's a gangster. That's how he like it.
What's up, buddy?
I know how he like it.
Hey, what's
No,
up?
you're gonna go that way with him.
I don't care.
Anything?
Okay.
Anything?
I know what he likes already.
Oh, okay.
I watch his.
Oh,
Yeah, you don't believe it?
All right, come on.
That why he ain't going back.
I would just double lock.
That why he's going back yet. Yeah.
Because it just happened quick.
It burns, yeah.
You just don't like this way they don't move on you.
Sorry to hear that. Hey.
Hold on, he's just
I just want to loosen
No,
them up.
He's loosening them.
Yo,
he's loosening
it's
them for
tight.
you.
How you listen?
He's doing it right now, look, buddy.
How's that feel? You want a little bit more looser than that?
A little bit. We're trying to
Are you
help you.
being serious? Or are you?
Yeah, no, we're helping you. We're trying to help
No, it feels the same,
you.
bro.
Okay, all right.
What about now?
Why the
As long as you can move
I'm
it
not
in
gonna
there.
play with you.
All right, my man. Step in there.
All right.
All right, step right in there.
Got it?
One leg at a time.
One leg
Yeah,
at a
watch
time.
your head.
Watch your head, all right?
Yo. That's right. Don't put nobody else in here.
That's his stuff?
Don't put nobody.
Yeah, that's his stuff, Harp?
Yep.
That's his stuff, his wallet, keys and stuff? Harp! Yeah, that's his.
The officers place Mr. Cox in the back of the transport wagon in handcuffs, but use no additional body or safety restraints to secure him in the vehicle seats, as the vehicle was not outfitted with seatbelts. Now, at the time of this encounter, the New Haven Police Department General Order 5.02 on so-called prisoner transportation did not require officers to secure prisoners in transportation wagons with seatbelts. Rather, the procedures simply required officers to handcuff the prisoner with their hands behind their back and palms facing outwards, conduct a search of the prisoner, place the prisoner in the van, and latch the interior and exterior door locks, meaning that the officers likely did not fail to comply with existing policy. However, there are also potential constitutional implications to the officers' actions. As the Supreme Court explained in the 1989 case of Deschaney versus Winnebago County Department of Social Services, quote, "When the state takes a person into its custody and holds them there against his will, the Constitution imposes upon it a corresponding duty to assume some responsibility for his safety and general well-being. The rationale for this principle is simple enough. When the state, by the affirmative exercise of its power, so restrains an individual's liberty that it renders him unable to care for himself, and at the same time fails to provide for his basic human needs, e.g. food, clothing, shelter, medical care, and reasonable safety, it transgresses the substantive limits on state action set by the Eighth Amendment and the Due Process Clause. In the 2012 case of Jabbar versus Fisher, the Second Circuit Court of Appeals, which has jurisdiction over Connecticut, held that the use of a bus without seatbelts to transport convicted prison inmates did not violate the Eighth Amendment's prohibition on cruel and unusual punishment, finding that, now quoting, "the failure to provide a seatbelt is not in itself, quote-unquote, sufficiently serious to constitute an Eighth Amendment violation. While seatbelts may offer, quote-unquote, reasonable safety for the general public, on a prison bus, their presence could present safety and security concerns. Inmates, even handcuffed or otherwise restrained, could use seatbelts as weapons to harm officers, other passengers, or themselves." Now, because Mr. Cox was a pre-trial detainee who had not yet been convicted of a crime, the failure to use a seatbelt would be analyzed under the Due Process Clause of the 14th Amendment, rather than the Cruel and Unusual Punishments Clause of the 8th Amendment. However, as the Second Circuit explained in the 2017 case of Darnell versus Pinheiro, the test is the same under the 14th Amendment as it is under the 8th Amendment. A pretrial detainee must show that the challenged conditions were, quote-unquote, sufficiently serious to constitute objective deprivations of the right to due process, and that the officer acted with at least, quote-unquote, deliberate indifference to the challenged conditions. Accordingly, because Second Circuit precedent has determined that the failure to provide a seatbelt to prisoners is not, quote-unquote, sufficiently serious to constitute a constitutional violation, a court would likely find that transporting Mr. Cox in the back of the wagon without a seatbelt or safety restraints on its own was not an infringement on Mr. Cox's 14th Amendment rights.
That's his stuff, his wallet, keys and stuff?
Yep.
While Officer Diaz is driving Mr. Cox to the detention center, he slams on the brakes to avoid hitting another vehicle, causing Mr. Cox to be thrown headfirst into the transport wagon. The video footage shows that Officer Diaz was traveling at 36 miles per hour, 11 miles per hour over the speed limit. Although the New Haven prisoner transport policy at the time did not include an explicit provision regarding speeding, it did state that, now quoting, "It shall be the policy of the New Haven Department of Police Service to take the precautions necessary while transporting prisoners to protect the lives and safety of officers, the public, and the person in custody." Additionally, while the failure to provide seatbelts to prisoners on its own may not rise to the level of a constitutional breach, courts have held that driving recklessly while transporting a handcuffed inmate without a seatbelt can amount to a violation. For instance, in the 2008 case of Brown versus Fortner, the 8th Circuit Court of Appeals noted that, quote, "Failure to provide a seatbelt to a prisoner while driving in a manner that puts the prisoner at risk of injury can constitute deliberate indifference to a prisoner's safety and health." Accordingly, there is a strong argument that Officer Diaz exhibited deliberate indifference to Mr. Cox's safety, breaching his constitutional duty to ensure, quote-unquote, reasonable safety for a person in custody.
Are you all right? That car went right in front of us and we almost got hit, bro. What's going on? I can't hear you. What's going on? What's going on? Huh? You what? You felt?
Yes.
All right, hold on. I'll help you out. Just give me a second, all right?
I can't.
You can't what?
I can't. I'm on my face.
All right, I'll get you an ambulance when we get there, okay?
No.
What do you mean no?
Brother.
I'm not gonna open the door now, so you know that, all right?
Let go. So call now. I can't move. I'm on my face.
I can see you on the camera. You're on the side. Get up.
Brother, I can't. I really can't move. I can't move.
How can you? All right, hold on. Let me stop somewhere. Hold on. What happened? What? You fell. What happened? Can you move at all?
I can't move.
Well, how your leg is all the way up there?
Understand me. Listen, brother.
All right, I can't move you, so I have to hold on. I'm gonna have to go get an ambulance.
Listen, no.
Huh?
Yes, but understand.
Go ahead.
I fall. I cannot move my arms.
All right, do not move. I can see moving your arm.
No.
Okay.
Look at my hand.
All right, hold on.
Help.
Hold on, I'm gonna call an ambulance.
Oh.
171.
171.
Can you start a signal 1? The subject in the van, he said he fell inside the van and he can't move. So I'm on my way to detention right now. So please, could you start me signal 1 over there? I got an ambulance coming. Do not move. Don't do anything. I got it. I understand. I already called you for an ambulance, okay? Try not to move. I'm gonna go nice and easy. The ambulance on his way. Did you were standing up when you fell? I'm asking you, did you were standing up in the back when you fell? Huh? Listen, I got an ambulance coming for you, all right? Just give me 1 second. I'm taking you there right now. I'm half a block away. All right, we made it. We made it here. We'll get you out of it in 2 seconds. I'm coming.
After realizing that Mr. Cox has been seriously injured, Officer Diaz leaves him in the back of the transport wagon, calls an ambulance, and continues driving him to the detention center, where he is met by Sergeant Betsy Segui, Officer Ronald Presley, Officer Jocelyn Lavandier, and Officer Luis Rivera. The New Haven prisoner transport policy requires that, quote, if the transporting officer becomes aware that a prisoner may be in distress, he or she shall immediately notify the dispatcher and render assistance when it is safe to do so. It also states that, now quoting again, prisoners requiring immediate medical treatment will be evaluated by medical ambulance personnel called to the scene. If deemed necessary by medical personnel, the prisoner will be transported to the hospital by ambulance. Accordingly, it seems likely that Officer Diaz violated the policy by transporting Mr. Cox to the detention center rather than calling an ambulance to the scene of the injury. Additionally, a person in police custody has a well-established due process right to prompt medical care if injured. In City of Revere versus Massachusetts General Hospital, the Supreme Court held that, quote, the due process clause requires the responsible government entity to provide medical care to persons who have been injured while being apprehended by the police, which, in the Revere case, included seeing that the injured individual was taken promptly to a hospital that provided the treatment necessary for his injury, and ensuring that the medical care needed was in fact provided. As with a condition of confinement, in order for a pretrial detainee to show that an officer violated the 14th Amendment by delaying or denying medical care, they must prove that the officer acted with, again, deliberate indifference to a serious medical condition. Here, Mr. Cox's serious medical condition was evident. He was laying on the floor of the wagon, unable to move. Although Officer Diaz did call for an ambulance, satisfying part of his duty to ensure that Mr. Cox received medical care, he arguably breached the duty by continuing to drive Mr. Cox to the detention center, delaying his access to medical care and potentially aggravating his injury, rather than just waiting for EMS where he had stopped the vehicle.
I'm coming. All right, I go for an ambulance. When on the way here, somebody calls me over, so I stop in the brake, but I don't know. He said he fell inside the van, and he's all, I opened the door and checked. I was talking to him, and he said he can't move. So if he really fell, I would not even move it until the ambulance gets here, because just in case.
Okay. I cannot move.
Cox, either we can move you or you can wait till AMR knows you.
I cannot move. I cannot move.
Okay, do you want us to help you?
It ain't gonna take my weight. Listen.
What happened?
If I can't take my weight, I cannot move.
Yeah, no.
I cannot move. I'm on one.
Just be careful. He was kicking the door and everything else before.
Alright, ready?
Try to stretch that leg first.
You see his leg?
You see that leg to the wall? Exactly.
Stretch out, Cox. Stretch your arm out.
Put your arm out.
Put your arm out. You don't have cuffs anymore. Take them out from behind your back. There we go. Now move your leg down. Move your leg.
Just roll it over to the side.
Listen, bro.
Sit up.
I can't move.
You're not even trying.
Tell him back, I get it.
Listen.
I'm not even joking about it. You gotta get him by the shoulder.
Look.
All right.
Turn your body.
You hurt me more.
No, I'm trying to turn your body.
Turn your body. You're not listening.
You're not even trying.
There we go. Turn your body. See?
Oh, hold on. That's
Okay, now stretch out.
Come on. Come on, or we're gonna pull you out.
Slide down, my man.
Oh, gee.
Yo, slide down so you can get out of here.
Look. If you gotta drive me, do it cross over.
All right.
Yep.
I look all right.
What's the hand?
All right, now, almost there. You're almost there. You gotta get your shoulders out. Ready? 1, 2, 3. Stand up. There we go. All right. Get up. Now, how you making up? Ready? Actually, no, go get that chair for me.
Get the
Yeah, we ain't.
wheelchair.
Hey, Rich, what's going on, man? Rich, what's going on? Huh?
You ain't cracking. You just drink too much.
No, I wasn't.
No, you drink too much.
Okay.
Sit up.
We ain't gonna take that way.
Yeah, no, we get the chair.
I was fine.
We're gonna try to be easy. Today's Sunday.
I was fine.
Listen, he was fine walking.
Yeah.
All right. Just, like I said, he was kicking that door, no problems.
Hold the tag door. Hold the tag door. Hold on. Ready? 1, 2.
I can't feel it.
Sit up.
Oh my God, yo.
Yeah, sit up. You're doing extra. Sit up.
Instead of waiting for the ambulance to arrive, the officers drag Mr. Cox out of the transport wagon and place him in a wheelchair. The universally accepted procedure where a neck injury is suspected is to avoid moving the injured individual and to immobilize the spine until medical professionals can properly stabilize and transport them, as unnecessary movement of a spinal injury victim can worsen the damage. According to the Mayo Clinic, if an individual suspects that someone has a spinal injury, they should call 911 or emergency medical help, keep the injured individual still, provide support to the neck by placing heavy towels or rolled sheets on both sides of the neck, or holding the head and neck to prevent movement, and avoid moving the head or neck as much as possible. The Mayo Clinic also instructs that a spinal injury should be assumed if an individual complains of weakness, numbness, or paralysis, and that if a spinal injury is suspected, the affected individual should not be moved, as permanent paralysis and other serious complications can result. Accordingly, the officers should have left Mr. Cox where he was and let paramedics handle his extraction with spine precautions rather than drag him out of the van and flop him into a wheelchair with no support for his neck and limbs. Not only did the officers' actions likely rise to the level of so-called deliberate indifference to a serious medical condition, but they may have also constituted an unconstitutional use of unreasonable force as well as violation of Connecticut criminal law. Under Section 53A-64 of the Connecticut General Statutes, quote, "A person is guilty of reckless endangerment in the second degree when he recklessly engages in conduct which creates a risk of physical injury to another person." Section 53A-3 of the Connecticut General Statutes explains that, quote, "A person acts, quote unquote, recklessly with respect to a result or to a circumstance described by a statute defining an offense when he is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstance exists. The risk must be of such nature and degree that disregarding it constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation." Well, here, by dragging Mr. Cox and placing him into a wheelchair without spine protection, the officers created a substantial risk of worsening his spinal injury, and doing so despite obvious signs of a neck injury could certainly be seen as conscious disregard of that risk. Likewise, Section 53-20 of the Connecticut General Statutes, which codifies the offense of cruelty to persons, makes it a felony offense for an individual to intentionally deprive another person of necessary food, clothing, shelter, or proper physical care, and a misdemeanor to do so, quote unquote, with criminal negligence. Under Section 53A-3, quote, "A person acts, quote unquote, intentionally with respect to a result or to conduct described by a statute defining an offense when his conscious objective is to cause such result or to engage in such conduct, while," now quoting, "a person acts with criminal negligence with respect to a result or to a circumstance described by a statute defining an offense when he fails to perceive a substantial and unjustifiable risk that such result will occur or that such circumstance exists." The quote continues saying, "The risk must be of such nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that a reasonable person would observe in the situation." Accordingly, while there is certainly an argument that the officers intentionally deprived Mr. Cox of proper physical care, they also almost certainly acted with criminal negligence in their actions.
Sit up. What else did you have? Did you have any drugs and alcohol?
Listen, no, I was fine.
You're not fine. How much? Okay. How much did you have to drink? Huh?
I asked my mother, I was fine.
I'm asking. Okay, but we're asking you now. We need to write that down for AMR purposes. Did you have a lot to drink? Any drugs?
No,
You feel like harming yourself? Okay. Any medical conditions we need to know about?
Right, can you,
All right.
check this pocket over here?
Okay, but yes.
Oh, no, you look right. I can go for it.
Put your hands out.
Put your hands in front. Don't move your head, gotta take off your earrings.
Neck hurt. I wish you did. You can't sit there.
Don't move your head.
Well, you're sitting all awkward. Even if something hurts, sit upright.
If I could, I would.
So we don't have to sit down?
Yeah, I mean, just to check them out, you know.
Again, probably because you're sitting there. Now, until you get AMR here, sit up.
Good.
You can put them in the holding tank.
Okay.
We're gonna have you sit in the holding
Cox,
tank
pick-
until AMR gets here.
You gotta pick up your feet.
Oh,
Pick up your
You
feet.
gotta pick
you're
up your
gonna
feet.
fall.
let me try it now. I'm telling you.
Go ahead.
Like, ow. Oh my God, yo, my neck, cause I can't.
No, Pops, let down. Don't work too hard. Not working too hard.
I can't reach.
No, we don't want you to wait. Don't worry about it. See that arm? Just grab his arm. There you go. Oh, sit up over here. Push it back like that.
Hey, can you put it?
Hold on, man.
Yeah.
Hold on, man.
Literally.
Mr. Cox was left handcuffed in the cell until an ambulance arrived. He was then taken to Yale New Haven Hospital, arriving nearly an hour after he was injured, where it was determined that he had suffered a cervical spine fracture resulting in permanent paralysis below his neck. On September 27, 2022, Mr. Cox, whose legal team included prominent civil rights attorney Ben Crump, filed a lawsuit against the 5 officers involved and the city of New Haven, claiming $100 million in damages. On October 20th, New Haven prosecutors dropped the criminal charges against Mr. Cox. And on June 9, 2023, the city of New Haven and Mr. Cox agreed to settle the case for $45 million, the largest police misconduct settlement in U.S. history. After the incident, the 5 officers involved were placed on administrative leave. Officer Presley retired before disciplinary action was initiated, but Officer Diaz, Sergeant Segui, Officer Lavandier, and Officer Rivera were all fired for their treatment of Mr. Cox. However, Officer Diaz appealed his termination, and in January of 2024, the Connecticut State Board of Mediation and Arbitration overturned the New Haven Board of Police Commissioners' vote to terminate Officer Diaz, issuing a 15-day unpaid suspension instead. City officials attempted to appeal the Labor Board's decision in court, but the court denied the city's application to challenge the arbitration ruling, and as of January 13, 2025, Officer Diaz was reinstated. The city of New Haven issued a statement confirming that Officer Diaz had returned to work, indicating that, now quoting, "While the city disagrees with the arbitration ruling, we are required to follow its direction." Now, on top of the disciplinary consequences, on November 28, 2022, all 5 officers were charged with reckless endangerment and misdemeanor cruelty to persons. The officers all pled not guilty to the charges, and they also applied to a so-called accelerated rehabilitation program that allows first-time offenders to avoid criminal convictions upon successfully completing probation. However, those applications were denied, and as of the date of writing this episode, episode, the charges are all still pending. The injuries suffered by Mr. Cox also sparked legislative and policy changes to protect the safety of individuals in police custody. On July 7th, 2022, less than a month after Mr. Cox was injured, the New Haven Police Department announced revisions to its transportation policy, issuing Special Order 22-03 regarding prisoner transportation to clarify and expand the requirements. The updated policy mandates that all prisoners will be secured in any transport vehicle by proper use of a seatbelt, and specifically prohibits driving at a speed exceeding the posted speed limit and using cell phones while engaged in the transport of a prisoner. The special order also requires officers to ask prisoners prior to transport and upon arrival at the detention facility during the intake process whether they are injured or need medical assistance, and record the responses on the body-worn camera. If a prisoner is injured, complains of injury, appears to be in an unstable medical status, appears to be in need of medical attention, or requests medical attention prior to transport, the officer is required to immediately contact their supervisor and request that EMS be dispatched to the current location. Finally, the revised policy states that if a prisoner is injured, complains of injury, appears to be in need of medical attention, appears to be in an unstable medical status, or requests medical attention during transport, or if the transporting vehicle is involved in a collision during transport, the officer is required to pull to the side of the roadway as soon as practicable, immediately notify the dispatcher to request EMS, immediately render aid consistent with their training or experience, and remain on scene to await the arrival of EMS. Now, in addition to the department policy changes, the Connecticut legislature passed 2 bills in June of 2023 that were tied to the Randy Cox incident. House Bill 6873 required the state's Police Officer Standards and Training Council to develop a model policy requiring the use of seat belts for people being transported and establish a disciplinary process for officers who violate the policy. Likewise, Senate Bill 1062 required police officers to request emergency services for people in their custody or in direct contact with them who experience a serious medical condition or are medically unstable. Overall, the New Haven officers get an F for demonstrating a profound degree of negligence for Mr. Cox's health and safety, for likely committing several crimes and policy and constitutional violations, and for exhibiting a total disregard for the basic human dignity of a citizen in their custody. The conduct of the New Haven officers wasn't just negligent, it was callous, institutionally enabled, and arguably criminal on many levels, beginning with Officer Diaz's decision to drive recklessly with a fully restrained passenger wearing no seatbelt in the back of a transport van. The conduct of the officers consistently reflected a level of negligence and indifference that goes far beyond mere procedural error. Not only was Officer Diaz speeding at the time of the incident, but his failure to immediately render aid after Mr. Cox's catastrophic injury directly contravened clear requirements to provide prompt medical attention and ensure the safety of arrestees. Rather than wait for EMS, as mandated by department policy and common sense, Officer Diaz continued to drive an immobilized, visibly injured citizen to the detention center, aggravating the injury and delaying life-saving treatment. Once at the facility, the conduct of Officers Presley, Lavandier, Rivera, and Sergeant Segui compounded the harm. Despite Mr. Cox's obvious signs of paralysis and distress, the officers dragged him from the van and then dumped him into a wheelchair without any effort to stabilize his spine, violating well-established medical standards for suspected neck and spinal trauma. Their actions directly contributed to Mr. Cox's permanent paralysis and sparked a record-breaking $45 million civil settlement, multiple terminations, and sweeping legislative reforms at both the city and state levels. One of the most troubling aspects of this encounter is the fact that, despite the overwhelming evidence of misconduct, Officer Diaz, the very officer who caused Mr. Cox's injuries and then delayed his access to medical care, was reinstated to active duty after his termination was overturned in arbitration. The city's inability to hold meaningful accountability in the face of such a catastrophic breach of public trust highlights the systemic failures that allow this level of misconduct to persist. The New Haven officers' treatment of Mr. Cox was inhumane, unlawful, and unconscionable, and if there were a lower grade than an F, they certainly deserve it. Now, as for Mr. Cox, I cannot rightfully issue a grade to an individual who was purely the victim of negligent police behavior. At no point in the footage does Mr. Cox act with aggression, resist arrest, or pose a threat to the officers involved. His injuries were not the result of any misconduct on his part, but rather the outcome of systemic failures, poor judgment, and gross negligence by those charged with his care. To evaluate his actions as if they contributed to the tragedy would not only be inappropriate, it would be a disservice to the truth of what occurred. Mr. Cox's role in this incident highlights the vulnerability of individuals in state custody and the absolute duty that law enforcement has to protect the citizens that they restrain and control. Mr. Cox's compliance throughout the encounter makes the officer's conduct all the more indefensible, and his catastrophic injuries serve as a grim reminder of what can happen when accountability breaks down at every level of the system. While no grade can capture the gravity of what Mr. Cox endured, his actions throughout the incident were measured, non-confrontational, and undeserving of the life-altering consequences he suffered. I commend Mr. Cox for following up this encounter with a lawsuit. And although no amount of money could ever replace what he has lost, I am very glad that he received some degree of compensation for what he was forced to endure. Let us know if there is an interaction or a legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to pick up your copy of the Civilian Rights Hand Guide in the links below.